All right, Mr. Simpson.
Just, Your Honor, my apologies, obviously, for wasting your time. That wasn't my intention. I have permission to blame the law. So,
That was, I take responsibility.
She's the one who handed it up to me, I remember.
I think our position's really been adequately covered. I would just say that, I don't think when we say go to the common law, that means necessarily that we have to go back hundreds of years. Going to the common law is to establish, case made law of the state. I think in Coon, as I've read on record before, sets, if you're inclined to charge fleeing felon, sets the fleeing felon standard in South Carolina as reasonable means to effectuate the arrest of a fleeing felon. Furthermore, says it's up to the jury to decide whether reasonable means were used. Lastly, if you are inclined to give some sort of Graham versus Conner charge, and it does read differently in different cases, but I know that in every time the defense put it in writing or speaks of it, they remove the word immediate. I've seen it as immediate, I've seen it as imminent, threat to an officer or others, and certainly if you go that way, we would think that that is a very important factor of the Graham versus Conner charge.
What charge would that be?
At its most basic, the Graham versus Conner charge is as asserted by Mr. Shealy, only with the element of immediate being added to it, that in order to effectuate arrest with deadly force, the officer must believe that the suspect is an immediate threat to himself or others.
Would the person have to be a fleeing felon in that scenario or not?
I think this charge comes up most often in the fleeing felon scenario. It seems to be a more modernization of what was the antiquated fleeing felon statute, that when effectuating the arrest of a fleeing felon, the person accused of being a felon must be an immediate threat to that officer or others. So yeah, I think it is a sort of...
If the jury determined he was a fleeing felon.
Yeah, and it is typically discussed in conjunction with a fleeing felon scenario. In Tennessee v. Garner itself, you had a person who was alleged to have been a fleeing felon from burglary. Yes. It's a very long answer. What I meant to say, Your Honor, was yes.
And how can Mr. Scott be a fleeing felon?
Well, again, our initial position is that he was not, or at least the evidence does not support that he was at the initiation of this chase.
I mean, we know fleeing felon is someone who robs the bank and he's on the run, someone who breaks in a house and the police trying to arrest him and catch him, someone who raped someone and trying to get away. I mean, isn't that how do we get a fleeing felon out of this scenario?
Again, I think in states that, and I think one position that me and Mr. Shealy agree is that our state could do a lot better in addressing this, but a lot of states have limited it to under the lay definition of a violent felony and have chosen to do that. Again, we're back to the issue that we were looking at the absence of that kind of action, either by statute or case law in South Carolina.
Well, under the resisting arrest case that, let's see, let me find that again. June 2013. Jason Husted, Husted case, 2013, this unpublished opinion where someone called the police on him and he ran off in the woods and they went after him. Our Fourth Amendment jurisprudence has long recognized that the right to make an arrest or investigatory stop carries with it the right to use some degree of physical coercion or threat thereof to effect it. You know, in that case, they use the phrase physical coercion or threat thereof. We didn't talk about shooting anyone.
Yes, Your Honor. I think really the issue is, particularly about Mr. Julie, though, is can a person begin a flight from police, just a fleeing suspect, and in the course of that flight, become a fleeing felon based on their actions in that flight. For instance, assaulting an officer while resisting, or taking a weapon, taking from an officer. Arguably, those are both under the statutes cited by the defense felonies. And so there you have the issue, and that's really what the court has to decide. Is can a person become a fleeing felony in the course of flight? We acknowledge that's an interesting issue, and again, we go back to if the court were to charge the fleeing felon statute, we would just ask for the language that we've requested from Law&Crime, which sets the South Carolina standard of reasonable means to effect the
All right.
and leaves that standard to the jury.
Well, I guess you all have to prepare to argue. If one way or the other, I'll think about it overnight and let you know in the morning on that particular thing. I can say that that I believe that the law is adequately laid out with regard to our standard jury charge on practically every issue in this case, and I don't need to go to common law or to Tennessee or to any other state or any civil case to find an appropriate charge that fits the facts.
May we request a copy of that standard charge that you're referring to, Ron, just to contemplate everything?
Well, the standard fleeing felon charge, I mean, I'm saying there's a standard charge for fleeing felon, lawful arrest, what is an arrest, all those things, and I know you all used to have it on your website. Thankfully it was taken down because the lawyers would make closing arguments directly from the judge's charge. So
And we don't have access to
good.
it.
All right. Well, yeah, I'll share that with you. From which I think if it's my view primarily is that this is a simple self-defense case now, but I'm going to look at it to see whether or not, based on the testimony and all the things that you all are suggesting, including the state's alternative argument, should be incorporated in some charge. I'll send you just a general, what standard, and then it might be a modification of what standard. That whole little section I emailed to you all. All right, what's next? And I have to digest Mr. Shealy's brief and all to see as well.
Judge, I'm still in favor of dinner. I was earlier.
Okay, all right. Well, it appears that both have requested a self-defense charge. Is that correct? No, I'm sorry. A voluntary manslaughter charge that both have requested.
Your Honor, what we requested in the charges was based on what we knew the other day. So we also requested some charges that we don't think are necessary. I know the court is bound to charge the law or whichever represents the facts underlying the case. We don't think there was heat of passion evidence in the evidence adduced up through today. We don't think it's necessarily correct that we would need a voluntary charge in this case, but we understand that's the court's discretion in the way.
So if I denied the directed verdict, as I did at the close of the state's case, you wanted either murder or not guilty?
Your Honor, I believe that is the case, but with Mr. Savage, Not here, I certainly wouldn't want to go out that far right now.
Okay, well, we'll revisit that in the morning.
Thank you.
You know, there's a great likelihood that whether you want it or not, that's what I'm going to charge.
Yes, sir.
Giving a copy of the jury charge to the jury, any objection to that?
The defense would be in favor of that, Your Honor.
All right, State?
Yes, sir.
All right, they'll be given a copy.
Assuming we like the charge tomorrow.
All right. Well, what else we need to talk about tonight, then? You know, the defense did a great job in giving me, how many pages? 47? 47 pages of requested charges. And a lot of them, the requested charges were based on what Mr. Shealy has argued. Aside from that, it seems to be a lot of rewording of what is a standard charge. You know, I've been doing murder cases for 16 years, and I have a charge that I'm comfortable with, wording that I'm comfortable with, and I will opt to use my wording rather than the wording that was provided to me. Now, and what else? Today,
Judge, just about scheduling for tomorrow, so we can get our head wrapped around what the sequencing of events might be to help plan out today.
there may be or may not be a reply witness, and so that would be I would anticipate that the jury we should be able to start arguing mid-morning. How long are you going to argue? You all going to argue? 1 hour, 2, 3? How long do you want to argue? Let me ask it that way.
Judge, I haven't fully processed the defendant's testimony. My guess, and I don't know what Mr. Savage is going to say before me, with those caveats, I think an hour and a half tops. We've been here for 4 weeks, 3 weeks. I hope it wouldn't be that long. I don't know that my voice will hold up that long, but I imagine there'll be a lot to say in reply to what Mr. Savage says. We would intend, depending on how much time in the morning you give us, to open on the law. I'll be a little more comfortable with what the law is before I set out and try to open on it.
Mr. Kim?
Your Honor, I'm not going to even speculate at how long the argument might be. I would point out that we have a pending motion before the court asking the state to open in full so that the defense has a proper chance to make the argument, and that there's a company memo, and we'd be happy to pull that out and argue now, but I think we discussed it briefly before.
If the state opens in full, what do they respond after Mr. Savage goes for an hour or two? What would their response be limited to, if anything?
Their response would be to rebut the allegations made in the defense's recitation of the facts and inferences to be taken from that. And as the memo points out, it used to be that way in the criminal court here in South Carolina. It got a little bit jumbled when the rules were being changed, and we went from one set of rules to 2 sets of rules. It's the way it's been in the civil side for a long time. The civil side has a much smaller burden, as this court knows, of just not a beyond a reasonable doubt burden. And then once again, the Supreme Court, at least in oral argument a couple of times this year, has certainly indicated, as one who has watched that a change to affect that will be coming soon. So I would just like the court to consider the fact that for the defense to mount a proper defense, that it has to have a chance to rebut the contentions that the solicitor makes, commenting on how the facts affect the law. Otherwise, the defendant is arguing negative.
Was that the rule that was erroneously put in the book?
Yes, sir, it was.
Remind me what that was again?
There was an effort to change the rule to what Mr. McCune has suggested, and it was not passed by the legislature. And
Which rule number is that, if you know?
I don't know, Your Honor.
Is the
I know
rule
there
on
were
it?
hearings on it.
Okay.
The defense bar presented testimony, solicitors presented testimony, Chief Justice McConis presented testimony, it did not pass.
And there was a judge who was looking in the book
Yes, sir.
and made someone go by the rule, then later discovered that
That's right.
there was an error in the book.
The bar had put out a book that incorporated the proposed rule, and the judge followed that, and we all got an email regarding it, and it caused a little bit of
Yeah.
chaos around it.
Well, I can say this about, I just asked how long you all plan to argue. I'm not one to, I've never limited arguments. It's your job to deal with the jury and convince the jury, and you put them to sleep, then that's your problem. But I've never imposed limits on argument. I ask so that there's some expectation so that you set your own time limit, at least be cognizant, have some thought about it, but.
I definitely will try to keep it moving, and we would ask that the court follows the current rule and practice in the state, and not do something special for this case. It's worked well for quite a long time, and that's why the legislature, I'm sure, decided not to pass it.
Well, I'm just saying is that it ends up being rather meaningless if you open in full, and then the defense spends an hour or two, then you can then respond in full as well. So the opening in full doesn't save any time or anything, because I'm certain that the defense will hit all the issues, and you'll be able to respond to everything that they hit. So, all right, what else?
There are, as you mentioned, I think our position on most of the charges requested of the defense would be just use the standard ones. There are a few, however, that are particularly, we don't think need to be charged at all. I can address those in turn if you want to just take a
Yes,
look.
sir, just give me the highlights of the ones you're talking about.
Request number 6 is a very strange request dealing with video. We think that they're pulling out, really asking the court to charge on the facts.
I never comment on the facts. I've given the law only, I don't comment on the facts. So that one's clearly out.
Request number 12, they request a charge on possession of cocaine. I can only assume that comes because the decedent had a small amount of cocaine in the system. I certainly don't think that warrants a charge of the criminal offense of possession of cocaine.
I'm not charging that.
Number 20, to me, is covered in the standard self-defense charge. 21 through 35 cover, I think, the Tennessee v. Garner debate. Obviously, if the court should decide to charge Tennessee v. Garner, we would want it quite circumscribed from the 15 or so odd charges that they requested. But we don't need to discuss that. We have to.
That's what we've been talking about, right?
Yes, Your Honor. If the form in which it's charged, if we get there, obviously, we can discuss. And then 41, their final
It would be a
request.
narrow one-page instruction that, similar to what I'm going to send to you all.
And finally, Your Honor, the last request, 41, asks you to charge some portions of the Personal Protection Act, the Stand Your Ground Act, then State versus Curry, 406 SC 364, and State versus McCray, 413 SC 76. Explain why at this stage, at the jury charge stage, when it hasn't been raised pre-trial pursuant to the standard procedures, charging any portion of the Stand Your Ground Personal Protection Act is improper. And that's their request number 41.
All right.
Oh, and I forgot, involuntary manslaughter, Your Honor. I don't think there's any construction of the evidence presented that would support a charge.
It was an intentional shooting. It cannot be involuntary.
That's precisely our position. Thank you.
All right. Anything else? Okay.
Not for the sake of it.
We'll recap all this in the morning. And also give Mr. Savage an opportunity to weigh in. All right. So we'll be in recess.
Thank you, Your Honor.